I want to ask you about the unfinished agenda. And before you list items on your unfinished agenda, I know yesterday in a press conference you mentioned InvITs and REITs and you would have liked to see some of them being listed before you left. But I think that process is already underway. There are half a dozen InvITs waiting to be listed.
Yes,
so that will
yes.
happen in due time. A couple of things that I thought that, maybe SEBI could have tackled in different ways. So let me start with one case that for the last 2 years I've been looking at very closely, wondering why SEBI has not taken further action. It is the case of SpiceJet. Now I know you don't comment on individual cases, but it's the principle of the matter that I'm bringing up here and not that particular instance. There was a takeover of the company. It's a listed company. The takeover happened through a restructure and revival scheme. The scheme somehow managed to get exemption under the takeover regulations, even though it was not a statutorily approved scheme. It was a scheme approved by a department of a ministry. And interestingly, in the 2 years that this takeover has happened, we still don't know at what price the incoming gentleman, that's Ajay Singh, bought the shares of that company, whether it was 1 rupee, 2 rupees, 5 rupees, 13 rupees as was the prevailing stock price then, or nothing. I'm just curious to know as to how SEBI has principally allowed for a takeover to happen without the disclosure of price.
I can't comment on this specific case, but you may be aware that in our takeover regulations, there are provisions that if any scheme has approval of the competent authority under any act of parliament, then the takeover code obligations will not apply. So, SEBI does apply this exemption whenever there are approvals from various competent authorities. On the question of whether in any particular case the share price has been disclosed or not disclosed, I am sure if it has not been disclosed and it is in violation of SEBI rules, SEBI will take action, or maybe it has already initiated action.
This happened in 2015, sir. We're sitting in 2017.
I can't discuss with you a particular case, I told you, but I am only informing you that if you think that there is a violation, and SEBI also thinks that there is a violation, then it will be taken to its logical end.
Was that the first time a competent authority was interpreted to be a department of a ministry by SEBI? Because often you all have accepted decisions by international regulators as competent authorities when it comes to, let's say, international merger schemes, etc. But to accept the Department of Civil Aviation or the Department of a ministry as a competent authority to approve a scheme and not a court, that has been the tradition at SEBI. Was that a departure from tradition?
This is not a correct understanding. Various ministries, various departments in the government have power of competent authority under various acts that they regulate or they administer. For example, in this case, could be that the ministry would have passed the orders under the Aviation Act. So, it's incorrect to presume that only judicial authorities are competent authority. Fortunately or unfortunately, there are situations where government departments also can be competent.
Another case I wanted to bring up, and again, you'll forgive me for making this case specific, but there's no running away from the Vijay Mallya situation. You know the history of this case as well as any of us do. 2012-13, Diageo comes and buys a majority stake in United Spirits. 2013-14, United Spirits discovers several issues with its accounting, therefore has to make very large provisions in the next financial year after a considerable delay of filing accounts. Auditors make all kinds of qualifications. So far, no regulatory action has been taken against the company. Thereafter, the National Stock, there was an internal investigation conducted at USL into those accounting irregularities. The National Stock Exchanges ask USL for the report of that internal investigation. The company says, sorry, we will not share it with you. Shareholders have no idea of who was found guilty in that internal investigation. Then Diageo enters an agreement with Vijay Mallya to get him off the board as chairman and pays him $75 million to do so. Till then, Diageo is supporting him as chairman because of some shareholder agreement that they have. And then finally, January 2017, SEBI wakes up and issues an order that debars Mr. Mallya from being on, any KMP position or being on the board of any company. There were several fronts on which SEBI could have taken action, but it's only in January 2017.
At least SEBI has taken action, that you admit.
Yes.
And the right way to understand it is that if any information is coming out in public domain, which may be an allegation there are stages provided for who is going to act on it, and in the first stage we ask, the rules provide that the stock exchanges have to ask for clarification, and then further developments take place. And we also have to follow a process rather than acting immediately on anything which is coming out in the media, unless it is something which is affecting the larger market or a large number of investors. So SEBI has taken action in this particular case. I must also tell you that the matter is not yet over, and if you look at our order very clearly, you will discover that the further investigations which are going on involving other players of this whole episode, that is also mentioned in the order.
But sir, it's been 2 years. It's been 2 years. 2015 is when USL's board asked Mr. Mallya to step down because of the accounting irregularities and the internal investigation that took place that cast suspicion on his role.
I told you earlier.
2 years. So I'm just wondering why the delay.
I told you earlier that we are now trying, and we are reaching a stage where nothing will be for more than 2 years. But if in this particular case it has taken 2 years, I am not particularly perturbed, especially because all the stakeholders or players in the drama are being covered by us.
Okay, there was one other thing I wanted to talk about. Again, a high profile case. You have made your mind and view very clear on it, but I'll still ask you about it. The issue of co-location at National Stock Exchange, the investigation that has gone on, their own internal audit. Now, I think the one or two places that SEBI came in for some criticism was when it asked NSE to conduct a self-audit, and I think there were eyebrows raised as to why the regulator is asking a potentially offending party to self-audit itself.
I am surprised that intelligent people continuously fail to verify the facts. What gives you the impression that SEBI asked the board to have an auditor and then take an action? Why are you not taking note of the fact that SEBI conducted its own investigation? I am surprised nobody is talking about it, and we had some of the best technical brains in this country.
Then why a self-audit?
Wait a minute. So, Technical Advisory Committee of SEBI did get into this issue over an extended period of time,
right,
and then they came out with certain findings. And you may be aware that after those findings, certain directions were given to the company, and those directions have been substantially implemented. The question of what was asked to the board or to the audit firm led by the board was to fix the accountability and responsibility. That who was responsible? Was there any manner of cover up? So, please do not forget that the whole thing has started because of SEBI taking up this matter very, very seriously. I am amazed that you are not talking about it. You are starting only as if that was the starting point.
No, my
please
point,
verify. Please verify.
No, I am aware of the SEBI technical committee that
did
its work at NSE.
That is where everything started.
So my question is this: I am trying to understand, and I understand that NSE is not any regular company. It is the country's largest stock exchange. But I am curious to know why ask the board to do its own investigation.
Because it is a new board.
If you thought there was a violation,
wait a minute. It's
why
a new
not
board.
SEBI do the investigation?
Please do not forget that SEBI has inducted new public interest directors there. It is an entirely new set of public interest directors who had nothing to do with running that exchange at that particular moment. They are new people, and they are very, very honorable people. So, it has been well thought out.
So, I was wondering
So first of all, SEBI ensured that the public interest directors are changed, new set of public interest directors who had nothing to do with what happened at that particular moment of history. And then they were asked to do what? They were asked to do only the verification and about fixing the accountability. SEBI can, and what gives you the impression that SEBI can't do it even now? If we are not satisfied with whatever findings are given, we reserve the right and we can go into it. But don't forget that the exchange that you are talking is an exchange which is a very large exchange.
I understand, which is why I said I can imagine that there was a different approach.
SEBI cannot be playing to the gallery and playing to the media. SEBI has to do something which ensures that the larger trust in the market is maintained. We have to do it in a very cautious way, and that is what we have done. And I am sure 5 years from now or even 2 years from now, all of you will appreciate the approach which SEBI has followed in this case.
I think it's the
This should not be
perception that
ignored.
if there is an offence that has taken place in a company, let's assume for a moment it's not a stock exchange and therefore it's not an institution as you're referring to. Would you, if there was an insider trading offence in a company, would you ask the board to investigate it and take action, or would SEBI investigate and take action? And I think the departure from that practice…
These examples are completely uncomparable.
No, so I'm saying departure from that practice is what raised eyebrows. Now, you may have very good reasons for why you thought that it was a different approach required.
You are not getting my point. It is not a departure in the sense that you are presuming that this was the only action taken by SEBI. You are refusing to believe that what action was taken through the technical advisory committee, which had very, very eminent people. And those eminent people did point out certain very specific deficiencies, and then action was taken.
If SEBI has investigated this, then SEBI would have come to some conclusions as to whether there was any preferential treatment meted out to certain sets of brokers, and if that was the case, then who was responsible for that preferential treatment?
Correct.
And if that was the case, then whether that person should be punished in any fashion. I use the word punished generically in that sense. But that hasn't been the outcome at SEBI. That has been something SEBI asked the board to look into. So, therefore, the curiosity as to why SEBI chose to ask the NSE board to do that as opposed to SEBI doing it. That's all.
Board to engage into a forensic audit so that the responsibilities could be fixed, and that exercise is ongoing. And if SEBI is not satisfied with what the findings are, nothing stops SEBI from getting into it directly.
Okay.
And don't forget that SEBI can't play to the gallery. SEBI has to ensure that something is done which doesn't destabilize the larger market. But yet the rules have to be followed. We are working in that direction.